Want to welcome you all. Thank you for joining us for today's Paid Family Leave Employer Q&A webinar. I'm Adam Rossi from the Stakeholder Engagement Unit here at the Workers' Compensation Board. Joining me today is Courtney Valley from our Office of General Counsel. And today we will be providing you with a brief overview of paid family leave. And we're going to review some of the most frequently asked questions we've received from employers and HR reps. And then we're going to spend the rest of your time answering any additional questions you may have. I mentioned shortly before, I know a lot of you weren't in here, we are going to be using the chat feature to take your questions. So if you have any questions, feel free to enter them in the chat box. If you look on the bottom right-hand side of your screen, you should see a little chat bubble icon. Just click on that and the box will pop right up if it's not up there already. We will answer as many of your questions as we can. However, we are going to be waiting until the end of this presentation to answer any questions. But again, feel free to enter your questions at any point during the presentation. Also, your name and email were given to us when you registered for this webinar. However, if you have a specific topic you'd like to discuss more deeply with the board, please feel free to share that topic along with your contact information in the chat box so that the appropriate board staff can follow up with you. We have the chat settings set so that only Courtney and I can see any questions or comments that come in, so you don't have to worry about others seeing your personal information. With that, though, we'll go ahead and get started with today's presentation. And as I mentioned, over the years, paid family leave benefits have been significantly enhanced to further improve the lives of working New Yorkers and their families, including providing more time off, more uses for paid family leave, and more financial security. So with these changes, we understand employers may have questions. So today, we are going to quickly provide a brief refresher on New York paid family leave, including what's new in 2024. We're going to review the most frequently asked questions from employers and HR reps about paid family leave, and then we're going to highlight some of the resources that are available to you. And then, as I mentioned, we're going to take the rest of the time to answer any additional questions you may have. To start, paid family leave is insurance, which is fully covered by employee contributions collected through a small payroll deduction. This critical benefit provides job-protected, paid time off to employees who need time away from their jobs to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones when a spouse, domestic partner, child, or parent is deployed abroad on active military service. Under legislation signed into law in March of 2020, paid family leave also provides paid time off and job protection so employees can care for themselves or their minor dependent child when under a mandatory order of quarantine or isolation due to COVID-19. The order must be issued by the state of New York, the Department of Health, local board of health, or any government entity duly authorized to issue such order due to COVID-19. And you can get more information on this by visiting paidfamilyleave.ny.gov/COVID-19. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2024, the New York State average weekly wage is $1,718.15. So that means the maximum weekly benefit for 2024, as you'll see right there on your screen, is $1,151.16. This is $20.08 more than the maximum weekly benefit from 2023. It is important to note that employees can take this paid time off all at once or intermittently. However, it must be taken in full day increments. So now let's go over some of the most frequently asked questions we've received from employers regarding paid family leave. Our first and top question: are employees who work outside of New York State eligible to take paid family leave? In order to be eligible for New York State paid family leave, an employee must be in the employment of a covered employer. To be in employment, an employee's service must be localized in New York State, which essentially means that the employee works either entirely or mainly in New York State. There's a test that we have that looks at all these requirements to determine whether an employee is localized in New York. The test looks at where an employee works. So they might live outside of the state, or the employer could be headquartered out of the state. But an employee who works in New York State is most likely considered to be in employment. Localization is a very fact-specific determination, but you can see this test and the factors considered in sections 201(6)(b) as in boy and C as in cat of the Workers' Compensation Law. Our next question. Must employees expand all other types of leave before becoming eligible for paid family leave? And the answer is no. Employers cannot require employees to use paid time off while on paid family leave. Employees cannot collect short-term disability and paid family leave benefits for the same period of time. So, for example, a birth mother can take short-term disability if she qualifies and then paid family leave, but she cannot take the short-term disability and the paid family leave at the same time. It is important to note that the total amount of time taken for disability and paid family leave cannot exceed 26 weeks in any 52-week period. If an employee has an event that qualifies for leave under both FMLA and paid family leave, and you as the employer are covered under both laws, you may require the employee to take the leaves concurrently. In order for the two types of leaves to run together, you as the employer must notify the employee that their leave qualifies for both FMLA and PFL, and that it will be designated as such. Our third question. If an employee's leave reason is covered under FMLA and paid family leave, can the employer require the employee to take paid time off at that time? So the Workers' Compensation Law does not allow employers to force employees to use accruals such as vacation or other PTO during paid family leave. However, the paid family leave regulations allow an employer to charge accruals in accordance with the provisions of FMLA when FMLA and paid family leave are running concurrently. Just want to note here that FMLA is federal and the board does not have jurisdiction over federal law. So we recommend employers do not require employees to use accruals when FMLA and paid family leave are running concurrently, but we can't demand that. Question 4. If an employee has exhausted FMLA, does paid family leave grant them an additional 12 weeks of leave? So as we mentioned, an employer may require an employee to use both PFL concurrently with FMLA. If an employer notifies an employee that a period of FMLA also qualifies for paid family leave, and the employee fails to apply for benefits, the employer and the insurance carrier may count the FMLA time against the employee's maximum paid family leave. If an employee uses FMLA for an event that doesn't qualify for paid family leave, then that employee will still have the paid family leave available. Question 5. Can an employee opt out of paid family leave if they work over 20 hours per week? Paid family leave coverage is not optional for eligible employees. Employees can waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week, but won't be in employment with that employer for 26 consecutive weeks. We always say that seasonal workers are a good example of this since they may work full-time, but they're only working for 3 months out of the year, so more likely than not, they would qualify to waive coverage. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form, which is also available on the Paid Family Leave website. Employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits, and employers should keep a copy of an employee's waiver on file. Question 6. Is there an employer match fund for the payroll deduction, or is this solely funded by the employees? Paid family leave is fully funded through employee contributions. Each year, the Department of Financial Services sets the employee contribution rate to match the cost of the coverage. In 2024, the payroll contribution is 0.373% of an employee's gross wages each pay period, and the maximum annual contribution is $333.25. If an employee earns less than the statewide average weekly wage, they will contribute less than the annual cap, consistent with their actual wages. Question 7. Can an employee take paid family leave more than once a year due to unique qualifying events? An employee may choose to use paid family leave for more than one type of qualifying event. Employees may take up to 12 weeks of paid family leave in every 52-week period. So it's a rolling calendar, not a calendar year. Keep that in mind. An employee who has multiple qualifying events within that 52-week rolling calendar will still be limited to 12 weeks total of paid family leave. Question 8. What is the process for submitting paid family leave request forms? Employees should provide employers with 30 days advance notice for their intent to use paid family leave if it's foreseeable. Employers should have the forms available for the employees. Employees must fill out Part A of the Request for Paid Family Leave form, which is Form PFL-1. And employers must complete Part B of that form and return it to the employee within 3 business days. If the employer fails to return the form within those 3 business days, the employee can still submit the form directly to the insurance carrier without the employer information. Question 9. When does the COVID-19 quarantine leave law expire? I mentioned this briefly, where you can now take paid family leave under an order of quarantine or isolation for either the employee themselves or their minor dependent child. We do understand that this does not happen very often, if at all, anymore. However, the New York State legislation that provides benefits for the COVID-19 quarantine leave does not contain an end date, so this is still in effect. Question 10. Is there any recourse if you suspect an employee is abusing paid family leave? If an employer believes an employee is abusing paid family leave, the employer should immediately contact their paid family leave insurance carrier to notify them of the situation. The paid family leave insurance carrier will determine whether the employee's paid family leave benefits are affected. So, as we continue working closely with employers to ensure successful implementation of paid family leave throughout New York State, we do have several resources to help. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources, including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and information about COVID-19 quarantine leave benefits. There is also a special updates for 2024 webpage. That link is on your screen right there, paidfamilyleave.ny.gov/2024. And there are a number of employer resources there to help explain and communicate benefit and deduction changes. These include an overview of the changes, some FAQs, updated model language for employee materials, an employee notice of paid family leave payroll deduction template, and a statement of rights for paid family leave. Employers and employees can also contact the Paid Family Leave Helpline at 844-337-6303 for assistance Monday through Friday from 8:30 a.m. to 4:30 p.m. And if you are not already subscribed for email updates on paid family leave, you can subscribe by clicking the Get Updates button on the bottom of paidfamilyleave.ny.gov. I mentioned this earlier. We are going to be providing you with a copy of this slide deck. We are also going to be providing you with a recorded version of this webinar. We will be notifying you via email when those are available, so make sure you are signed up for email notifications. Finally, we also want to make you aware of the board's Advocate for Business. The Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it pertains to your business. You can contact the Advocate for Business office at advocatebusiness@wcb.ny.gov. So that does it for this presentation. We hope you found it very helpful. As I promised, we are now going to take the rest of the time to answer any additional questions you may have. We have Courtney Valley. She is on hand. She's going to take a look at some of the questions that have already come in, and as well as the questions that you guys may have, later in the presentation. Again, feel free to put it right in the chat box. There's a little chat bubble icon at the bottom of your screen. Just click on that. The box will pop right up, and you can enter your questions that way. We do have a few questions that have already come in, so I'm going to put our resources page back up here for the phone number and the website. Again, sign up for email updates so that you know when the copy of this presentation and the recorded version are available. It usually takes a few days to edit and get it all approvals, so just be on the lookout for that. Now, though, I'm going to hand it over to Courtney, and she's going to go ahead and answer some questions.
All right, thanks, Adam. So the first question I see here is, are employees allowed to tell us at the end of their PFL that they will not be returning as an employee, or do they have to give us notice? So what if an employee was out on PFL and they were the day that their leave ends, they say they're not returning. So there's nothing in the PFL law or regulations requiring an employee to return to work in order to receive PFL benefits. And we do see this occasionally where an employee isn't giving notice that they're not planning to return for leave, and most of the time that's because they're worried that they're going to be fired, or their employment's going to be terminated while they're on leave. But there's nothing in the PFL law or regulations requiring them to return to work in order to receive benefits. And there's nothing specific requiring them to provide notice that they're not going to return after leave either. Okay, the next question I see here is, do payroll transactions have to be done for this leave? How are time cards coded for PFL? So I can't provide legal advice, and that is going to include any guidance on your business practices, like how you process your payroll and things like that are outside of the purview of the PFL law, so I can't provide guidance on that either. Generally speaking, the benefits are going to come from the PFL insurance carrier, so they're not coming as wages from the employer. An employer could certainly top up, provide additional benefits, or pay full wages and request reimbursement from the carrier. But generally speaking, paid family leave benefits are not wages from the employer, they're benefits from the PFL insurance carrier. Okay, next question here is about an employee that qualifies for a waiver. We notified the individual and they have not responded, so now we've begun taking deductions, or should we assume that they're going to fill out the waiver and refund any deductions that were already taken? So this is not specifically addressed in the regulations about the waiver, but there's nothing saying that you couldn't say, here's the waiver, you qualify for waiver. If you don't respond by this date, we're going to assume that you don't want to execute the waiver and you don't want to opt out, and we're going to take deductions. So there's nothing in the regulations that would prevent you from doing something like that, but you do have to offer an employee who qualifies for a waiver the chance to opt out before you take deductions. Right, next question here is, does a rolling calendar mean the date from which the request is first approved in a 52-week period? So if we're talking about someone who's never taken paid family leave and they're going to take paid family leave, their rolling calendar is going to start on the first day of their leave for that period of PFL. And then the regulations define it as it's 52 consecutive weeks or calendar weeks computed retroactively with respect to each day for which benefits are currently being claimed. So what that means is like for each day that an employee is taking PFL, the carrier is going to look back 52 weeks, and that informs how much leave that the employee is entitled to. So it's always rolling calendar, and you're kind of looking backwards 52 weeks to see how much leave you've taken. So if like in the past 52 weeks, the employee has taken 12 weeks, then they're not eligible for any additional leave. But yeah, the calendar is going to start on their first day of PFL. Okay, next question here is with the CDC no longer requiring mandated quarantine, how does COVID-19 pay work? So the COVID-19 quarantine leave law provides benefits when an employee or their minor dependent child is under a mandatory or precautionary order of quarantine or isolation. If there are no mandatory or precautionary order of quarantine or isolation, that's the only way that benefits are available under this law. It is still a law that's on the books. Whether or not anyone is eligible for it is another question. I can't provide legal advice, which includes eligibility determinations, but the only way that someone is eligible for this COVID-19 quarantine leave law is if they are under a mandatory or precautionary order of quarantine or isolation, or their minor dependent child is. Okay, next question is asking about what a carrier should do if there's fraud. The board doesn't regulate insurance carriers, and I am not very familiar with how carriers deal with fraud. On the employer side, they should always report it to the carrier. Because I don't work in insurance and I am not super familiar with what the laws surrounding that are, I unfortunately can't provide you too much detail with what a carrier does when fraud is committed. Okay, next question here is, can an employee work part-time but use PFL also? For example, a new mom wants to return to work part-time and work 3 days a week and use PFL for 2 days a week. Yes, this is PFL is available either continuously or intermittently in increments of 1 full day. So it's not available hourly, but it is available in increments of 1 full day or for weekly blocks. So like when we're talking about continuous leave, if someone's taking 12 weeks of leave, that's just going to be their 12 weeks and then they're done. But you can take PFL intermittently. So if you don't want to take it in weekly chunks, you can take it in increments of 1 full day. So if you want to do 3 days a week and then take PFL 2 days a week, you just have to keep in mind the employee has to keep in mind the notice requirements. The employer can require notice before each day of intermittent leave, but that is something that an employee could do, is kind of break it up as long as it's increments of 1 full day and not hourly. Okay, next question here is, if an employee is pregnant and will be going out on PFL for the full 12 weeks for bonding, can she also apply for short-term disability for an additional 12 weeks? And does it matter how many employees a company has? So I'll take the last question first and then we'll work into the others. So a covered employer for New York State PFL is a private employer with 1 or more employees in New York State on each of at least 30 days in a calendar year. So it's virtually all private employers are covered for disability and PFL. They're both under Article 9 of the Workers' Comp Law, so there's no kind of difference with disability and PFL. It's just if you have 1 or more employees in New York, essentially, you are covered and you're required to have that coverage. When we're talking about PFL and disability, a lot of times if the person who's pregnant, they give birth, they're likely eligible for 6 weeks for an uncomplicated vaginal delivery or 8 weeks for a C-section. That's like the general disability that you're kind of automatically entitled to after you give birth, assuming you're eligible. But so after you give birth, it's generally 6 weeks or 8 weeks. Obviously, if there are complications, there could be more. The 12 weeks of PFL is your maximum PFL. There's also a combined statutory maximum of 26 weeks of disability and PFL under the Article 9. So statutory disability and PFL, there's a max of 26 weeks in a 52-week period. But generally speaking, when an employee gives birth, it's going to be the 6 or 8 weeks, and then they're going to take the PFL if they want to take both. That's generally how they do it, is 6 weeks disability to recover from the birth, and then the 12 weeks bonding. Okay, next question here is, we are in Canada and opening a location in New York. The government gives guidance for the premiums, but we need to sign up with a private insurer. Is this correct? So yes, like the PFL works a little bit differently than a lot of states that have PFL. A lot of them are just directly through the government. They're run through the government. Ours is a little bit different because it is a private insurance product. So a covered employer, like I just said, the 1 or more employees in New York State, blah, 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 they're required to purchase insurance coverage. And you can find a list on that paid family leave website. And then if you go to the employer responsibilities page, there's a link to all of the approved insurance carriers who write disability and paid family leave insurance policies. So you would purchase a policy, and that is your statutory coverage. They're going to fill out like a certificate of insurance and send it to the board. So your responsibility is to purchase coverage for your covered employees in New York State. And then, yes, so if an employee takes paid family leave, it's going to be processed by your disability and PFL insurance carrier. They're the ones who are going to pay benefits. And then when you take deductions from your employee or employees, depending on how many you have in New York, when you take deductions from them, you use those deductions to pay your PFL insurance policy premium. So that's the rate that we were talking about earlier. The rate is set by the Department of Financial Services every year, and that matches, so the contribution rate matches what the insurance carrier can charge for your insurance policy premium. So you take the deductions and then you give those deductions to the insurance carrier that pays for your insurance coverage. Okay, I see another question here about the COVID quarantine. Sick leave is not a replacement for those days. Correct. Correct. These are days like if an employee or their minor dependent child is under an order of quarantine or isolation, these days, if you're required to provide the paid sick time, those are separate from normal sick time. Like they're separate and apart from any of those. They're their own category of leave that employers are required to provide, and they are separate. Okay, next question here is, if an employer requests the PFL forms on a Friday and plan on taking the day off to care for a family member with a serious health condition the following Monday, but they still haven't submitted those completed forms to the insurance carrier, should they take PTO for that Monday? Or would it be benefits through PFL? So generally speaking, employees have 30 days from the first day of leave to send their completed request to the carrier before they risk losing benefits. And the carriers have 18 days from receipt of a completed request or the first day of leave, whichever is later, to pay or deny the request. So in almost every single case, the employee is going to be out on PFL before they actually get paid for the PFL. So that's virtually every single case, unless an employer and a carrier is allowing a pre-filed claim. Almost every single time, someone is going to be out on leave before they've actually received either a decision or definitely payment on their request for PFL. So when they get the approved benefits, they will be paid retroactively to the first day of leave. So if they're taking PFL, and they can't receive more than 100% of their wages during a period of PFL. So that's just something to keep in mind as well. Okay, next question here is there a cap on the weekly deduction withheld from employees if they earn more than 17, 18, 15? So the rate for deductions for PFL is this year is 0.373% of an employee's wages each pay period. And then there's an annual max of $333.25. So like an employee who makes a lot of money is likely going to have large PFL deductions at first, but then they're also going to stop much sooner in the year than someone who makes less than them, because once they hit the $333.25, they're done for the year. So at that employer. So it's just a matter of it's per pay period. It's a per pay period deduction, but it's capped at the annual max. So it's not necessarily weekly max. It's an annual max and a pay period max. So it's the 0.373% of their wages each pay period. And then once they reach that annual max, then that employer can no longer take deductions from them for that year. Okay, next question here is, what employers are exempt from New York paid family leave? So a covered employer, like we talked about, is a private employer with one or more employees in New York. So public employers are not subject to the law. So they can opt in if they choose, but public employers are not subject to the PFL law. Okay, I see a question here about is FMLA documentation required if it's being taken concurrently with PFL? That is a question of federal law, and we don't have jurisdiction over federal law. So that's really a question for the United States Department of Labor. They may require it. I am not familiar if there's a PFL. I don't know if they, if the FMLA documentation doesn't need to be provided. It's a federal law, and we don't have jurisdiction over federal law. Okay, next question here is, if an employer has 100% paid parental leave and the last 2 weeks of the parental leave overlaps with state bonding time, does the program allow for full pay from the employer for the first 2 weeks of leave? So if how PFL and an employer's leave policy interacts is going to depend on the terms of the employer's policy. If an employer is paying full wages during a period of PFL, they are free to request reimbursement from the insurance carrier. So if they're paying 100% of wages to the employee, they can request reimbursement. Say I'm paying full wages. I want reimbursement, and what that means is that the carrier would pay the benefits to the employer, so that the employee isn't getting more than 100% of their wages. But I can't provide legal advice on how your policy is going to interact with New York State paid family leave, but just if you're paying full wages, you can request reimbursement. Okay, the next question is very similar, so I'll just kind of reiterate, asking if an employee can double dip to receive payment from the employer and through the state. So like we have 100% paid parental bonding. So again, it's just going to depend on the terms of your policy, whether they have to be taken at the same time, whether they can be taken separately. If you're paying 100% of wages, not through use of accruals, like if you're paying 100% of wages, you can request reimbursement. Employees just can't receive more than 100% of their wages during a period of PFL. But how an employer policy and New York State paid family leave interact is going to depend on the terms of the employer's policy. Okay, next question here, asking if there's an employee limit to offer PFL to your employees. So it's one. So if you're a private employer with one or more employees in New York State on each of at least 30 calendar days, you are covered for disability and PFL, and you have to purchase coverage for your covered employees. But keep in mind that the PFL deductions are entirely cover the cost of having those employees on your PFL insurance policy. Okay, next question here is if an employee has an elderly parent who is in ill health who lives out of state, does PFL cover the employee having to help move their parent in with them? So I can't provide legal advice, which would include eligibility determinations or kind of specific whether or not a specific situation qualifies for PFL, but assuming that the parent has a serious health condition, the providing care for a family member with a serious health condition is a qualifying event for PFL. And providing care is defined very broadly. So like transportation, visitation, assistance with essential daily living matters, like all of those things are covered under providing care. So it is defined very, very broadly. So assuming that the employee's family member had a serious health condition, it is possible. Okay, next question here is, do you need to be employed at the agency any length of time prior to using this insurance? So if you're talking about the employer, yes. So an employee who regularly works 20 or more hours per week becomes eligible for PFL after 26 consecutive weeks of employment with a covered employer. And an employee who regularly works less than 20 hours per week becomes eligible after actually working 175 days in the employment of a covered employer. Okay, next question here is about, should we start deducting for PFL immediately upon the acquisition of a company, even though the employees won't be eligible for PFL for 26 weeks? Yes, so generally speaking, deductions for PFL can begin as of the first date of their employment in New York State. So you do not have to wait for them to actually gain eligibility before taking deductions. It is to cover the cost of having those employees on your PFL insurance policy. Okay, next question here is for the waiver, working 175 days in 52 weeks. Is that a rolling year as well or a calendar year? So it's just 52 weeks. So it's if they won't work 175 days in a year, essentially, I guess that could be rolling because they could be hired at any time, throughout the year. So it's if they won't work 175 days in a year, like we're really getting at, does this employee work a lot or do they work a very little amount? So if they're not working 175 days in a year, they're not working a lot, and that's why they're eligible for the waiver. So it doesn't specify, but it is just kind of in a year, like in 52 weeks, do they work 175 days? It does not mean like January 1st to December 31st necessarily. Okay, next question here is, if an employee regularly works 4 days a week and they're going to take intermittent leave, are they eligible for 48 days of PFL, whereas a 5-day per week employee would get 60 days maximum? So section 380-2.5 of the regulations is where you're going to find like the how to calculate intermittent leave. But it's going to depend right on like if they're taking it weekly or if they're taking it intermittently. If we're talking about intermittent, just days of leave, it's however many days a week they work times 12, because the maximum is 12 12 weeks of PFL in a 52-week period. Like that doesn't necessarily translate perfectly to like weeks when we're talking about if you're taking 12 weeks of leave, obviously like you're not working the whole week. If we're talking about taking intermittent days in increments of one full day, then yeah, it's if they work 4 days a week, it would be 4 times 12 versus if they work 5 days a week, it would be 5 times 12, and that's the number of intermittent days per week that they're eligible for. Okay, next question here is, what about an employer who provides COVID quarantine paid sick leave? Do the employees there still qualify for PFL COVID sick leave? So if you go to the paid family leave website and then on the top right hand corner, there's a COVID-19 button. That has kind of the information about what size and type of employer and what benefits they have to provide. Like there are some employers where it's just straight COVID-19 quarantine PFL. There's some where it's a combination of COVID-19 sick leave and PFL. There's some where it's just COVID-19 quarantine paid sick leave. So if we're talking about, for the sake of this, we'll talk about like the middle tier because that has some combination. An employee has to use all of the COVID-19 quarantine leave that's available to them before they would be eligible to take COVID-19 quarantine PFL. So if we're talking about their own order of quarantine or isolation, again, though, just to kind of reiterate this, a prerequisite of being eligible for this quarantine leave is that you are actually under a mandatory or precautionary order of quarantine or isolation. Okay, next question here is an employer noticing a trend with employees requesting PFL for July because of a scheduled vacation. So they have a 4-week vacation scheduled and they schedule a 12-week PFL. Is this allowed? So generally speaking, an employee can choose whether or when to take PFL if they're eligible for it, and an employer can't discriminate or retaliate against them for taking or requesting PFL. Now, the vacation time is something separate, and that is unrelated to PFL. So like time off that away from work that isn't PFL is outside the purview of PFL, and it's going to be subject to the employer's normal business practices and their, that's outside of PFL. But generally speaking, for PFL, if the employee is eligible for it, they're giving appropriate notice. The employer has no say in whether or not the employee can take PFL. Okay, next question here is, we are a Michigan employer who hired a remote employee who lives and works in New York State. What's the best way to enroll in a PFL insurance coverage plan because our current provider won't do that for a single participant? So a covered employer is, like we've said a few times, is if you have one or more employees in New York, you are covered, and you do have to have insurance coverage. If you go to the paid family leave website that's on the screen, and then you click like employers and then like employer responsibilities and resources, there is a link to the DFS webpage that has all of the insurance carriers that are authorized to write disability and paid family leave insurance policies in New York. So you may have to call a few of them. One of them, you'll have to purchase coverage from them if your current provider won't do it. Okay, next question here is, what recourse does an employer have for employees who only give a few minutes notice or hours after shift starts that they're taking PFL? So generally speaking, employees are required to provide 30 days notice of foreseeable leave and as much notice as possible if the leave is not foreseeable. If you don't think that they're providing sufficient notice, like if you think that they should have provided more notice and didn't, you can contact your disability and PFL insurance carrier because they're the ones who are going to process and pay or deny the request for PFL, and they do have the ability to issue partial denials if there's not appropriate notice. Okay, I see several questions kind of sprinkled throughout asking about what counts as an order of quarantine or isolation. This is really outside the purview of the PFL law. It's not in the PFL law what counts as that. The law just says issued by New York State, local board of health, things like that. But as far as if X specifically counts, I can't provide legal advice, so I'm not going to be able to kind of go through and say like, yes, this counts, no, this doesn't count. So that's really, unfortunately, I don't have a good answer for what counts as an order of quarantine or isolation. Okay, next question here is, if employers require the use of FMLA and PFL concurrently, then the employee only gets 12 weeks as opposed to 24 or 18, correct? So FMLA and PFL, like, because I see here we're talking about like disability and PFL as well. An employer can require available FMLA and PFL for the same qualifying event to be taken at the same time. So bonding leave is a great example of this because it's covered under both FMLA and PFL. If an employee is going to take 12 weeks of bonding leave and they also are eligible for and have 12 weeks of FMLA available to them, you can require those to be taken at the same time. But if, for example, an employee is eligible for FMLA and they're taking 6 weeks of disability before they take paid family leave, that time cannot run concurrently with paid family leave because paid family leave does not cover leave for yourself. So leave for a serious health condition is for your own serious health condition is not covered under PFL. So therefore, those 6 weeks of FMLA do not run concurrently with PFL because there's no corresponding PFL qualifying event. So it's going to be if they take like 6 weeks of disability and 6 weeks of FMLA for that, and then immediately after that they take bonding leave, like the first 6 weeks may run concurrently FMLA and disability, but then it would be the first 6 weeks of PFL, and then the last 6 weeks are just PFL because there's no more FMLA. They've used up all of their FMLA, so they don't have it available to them. So it's only leave that's available to them. It doesn't mean that you cut off their ability to get PFL. So disability and FMLA, that does not count against your PFL time because it doesn't qualify for PFL. Okay, next question here is if our company is located in New York State, but we have a company working remote from another state, are they eligible for PFL? The answer is no. An employee who does not work in New York State, so they have to be considered in employment for New York State PFL, you have to work in New York State, essentially. You have to be localized in New York is what the law calls it. If you're not localized in New York, you are not eligible for New York State PFL. Okay, next question here is if an employee chooses to, can they take paid time off while they're waiting for their PFL to be approved? So if an employer allows them to, they could take paid time off, but again, they can't receive more than 100% of their wages during a period of PFL. So what a lot of employers do is they'll let them like top up. So from the 67%, then like say like 30% so that they get 100% of wages. You could do that. The employer could pay full wages and request reimbursement, but employees cannot receive more than 100% of wages during a period of PFL. Okay, next question here is for the max amount of deductions per year, is that based on calendar year? So yes, it's the 2024 rate that's set by DFS is the current amount. And then in September, I believe it's like September 1st, the Department of Financial Services will issue the next year's rate so that employers can kind of get ready for it and employees know what's going to come out of their paycheck, but those deductions at the new rate can't start until January 1st of the following year. So it's an annual max, and that one is based on the calendar year because it's a rate that's set each year that takes effect on January 1st of each year. Okay, next question here is I see a list of approved PFL companies on your website. So can we use just the approved standalone PFL plans? Our insurance company is not on the list. No, if you're a covered employer and you have an employee in New York State and you're looking to come into compliance as a covered employer, you need both statutory disability and PFL insurance. You can't just have paid family leave. A covered employer means you're covered under Article 9 of the Workers' Compensation Law, which includes both statutory disability and PFL. So you're not going to be able to get a standalone PFL if you're a covered employer. It's disability and then a rider, which is PFL, that's on the, it's a rider on the disability insurance policy. So you're not going to be able to, if you're a covered employer, you can't get a standalone paid family leave unless you were already like an approved self-insurer for disability, which doesn't apply to you because you're becoming a covered employer. So if you're a covered employer, you have to have coverage for both disability and PFL, not just one. Okay, next question here is if the employee chose to execute a waiver, but then wants to change their mind and participate in PFL contributions, can they do that? And is there a waiting period before they can use PFL? So yes, the waiver is optional and an employee can revoke it at any time. If they do choose to revoke it, the employer can take retroactive deductions to cover the cost of having that employee on their PFL insurance policy. There's no waiting period other than like they have to actually be eligible. So if like we're talking about someone who works less than 20 hours per week and they won't work 175 days in a year, but then they get kind of close and they're like, I actually don't want to waive coverage anymore because I might end up using this even though it's not going to be a big benefit. Like I want it. I want to revoke my waiver. They can do that. And then once they reach eligibility, they'd be able to take PFL if they've revoked their waiver, but the employer can then take the retroactive contributions to cover the cost of having them on the policy and going forward as well. Okay, next question here is, besides hanging posters about PFL and putting it in our handbook, what training or explaining do we have to provide employees about this right? And so there's also a statement of rights that employers have to provide to employees. But if you go to the Paid Family Leave website and then click the employer tab, and then there'll be like employer rights and responsibilities. If you go there, that has a lot of information about employers' responsibilities under PFL. Okay, next question here is asking if hybrid workers qualify for PFL. So if they work 4 days in New York and 1 day in another state, are they still eligible? So I can't provide legal advice, which includes making eligibility determinations for particular individuals. But if they are considered localized in New York State, then they may be eligible for PFL. So if the work out of state is temporary or transitory in nature, things like that. So it's section 2016 of the workers' compensation law. That's where the localization test is, but I can't provide legal advice, so I'm not going to be able to tell you whether or not an individual in that situation is actually considered localized or not. Okay, next question here is, if an employee takes 6 weeks under disability for having a baby, and that's part of her FMLA, can she take 6 more weeks of FMLA for bonding? And then is that 6 weeks also under PFL? And then she can get an additional 6 weeks of PFL bonding? Yes. So if I'm understanding you correctly, yes, I think that is what I was trying to explain before and maybe didn't do a good job, is that generally speaking, FMLA and PFL for the same qualifying event, assuming that you have both leave available to you, the employer can require those to be taken at the same time. So we know there's 12 weeks of FMLA available and there's 12 weeks of PFL available. So in this situation, if an employee takes 6 weeks of disability and that 6 weeks is concurrent with FMLA, so that's 6 and 6, and then they want to take 12 weeks of bonding, and you want to run the FMLA concurrently with the bonding leave, and they still have 6 weeks available to them, then right, it would be the first 6 weeks of PFL would also be FMLA. So then after that first 6 weeks, they've exhausted their 12 weeks of FMLA. So they have no more FMLA available to them because they used 6 weeks for their own serious health condition and then 6 weeks for bonding. If they're assuming that they're eligible for PFL, they can still take the additional 6 weeks, even though now it's not concurrent with FMLA. So FMLA does not affect their eligibility for PFL at all. They're completely separate benefits. The only thing there is that you can require them to be taken at the same time. But yes, you're correct. It would be like the 6 and 6, then 6 and 6, and then 6. Okay, next question here is there a circumstance where a person takes their PFL intermittently and exhausts it, and then immediately requests continuous PFL? Could that be approved? So for every day that the employee is requesting benefits, the carrier is going to look back and see how much leave the employee has taken. If it's 12 weeks, they're eligible for nothing. If it's 11 weeks, they might be eligible for 1 week. If it's 10, and so on and so forth. So they're always going to be looking back the last 52 weeks to see how much leave has been taken. So the employee is earning it back on a rolling basis, but it's not, they don't immediately then get a new 12 weeks. It's a rolling calendar period. So the carrier, for every day that benefits are claimed, you're looking back 52 weeks to see how much leave has been taken. Okay, next question here is, does the employee need to keep a copy of the medical doctor documentation? So it's always a good idea for the employee to keep copies of their applications for benefits in case something goes wrong or in case they need to provide more information or things like that. But the healthcare provider certification, if that's what we're talking about, goes to the insurance carrier so that they can make a decision on the request for PFL. But always a good idea to make a copy for your own records if you're applying for PFL. Okay, next question here is, the waiver doesn't say I decline PFL, it only shows the number of hours worked, or that you won't. So the waiver is, you're only filling that out if you're trying to not take PFL, if that makes sense. So the waiver, let me pull up, I'm sorry, I'm just going to pull up a copy of it. Yeah, so the waiver, it does say like the heading. So in the part where it's asking about your schedule, correct, it doesn't say that you're opting out, but the title of the form and the header of the form and information on how to opt out, it says employee opt out of paid family leave benefits, and then it says information on the option to opt out, and then it says, you know, I understand that I'm opting out. I understand that my employer can't force me to, and my employer will keep a copy. So it doesn't say I decline PFL because by definition, this is an opt-out form. Like, you're only filling it out if you're trying to opt out of paid family leave. And you can only opt out of paid family leave if you fit in those two categories of employees.
All right, thank you, Courtney. Wow, that was a lot of questions. We covered the full hour. That's fantastic. We always appreciate your participation. Kudos to Courtney for answering almost every question we got. That's a good job by you, Courtney. Hats off. We are going to go ahead and wrap up today. Just a quick reminder, if you did have a question that we didn't get to, or if you think of something later, feel free. When you sign out today, you're going to have a little post-webinar survey. It's going to take a couple minutes just to ask you questions about how we're doing with these webinars, anything we can do to improve. But we also have a section where you can fill in anything if you want us to follow up with you on anything. So if we didn't answer your question, or if you think of something within the next few minutes, feel free to type it in there and we will make sure to read that and get back to you. Also want to remind you to please sign up to receive paid family leave news, including information on future webinars, straight to your inbox. To sign up, visit the Paid Family Leave website. Just scroll down to the bottom of the homepage and select the Get Updates button. Again, we are going to be sending you a notification when the recorded version of this webinar is available, along with a copy of the slide deck. And we do also distribute information via social media. So make sure you're following the Workers' Compensation Board on Facebook, X, Instagram, and YouTube. Again, thank you everyone for joining us today. Thank you for the participation. We always appreciate it. Thank you to Courtney for taking the time to answer your questions, and enjoy the rest of your afternoon. Thank you.